Good morning, Your Honor. May it please the Court, Alexandra Valdez on behalf of Mr. and Mrs. Powell, the appellants. I would like to reserve 3 minutes of my time for rebuttal.
Okay, you can see the clock as well as I can, but I'll try to remind you.
Thank you. I'd like to begin, if I may, with the jurisdictional issue that was raised by the Court in its April 1st, 2020 order. As the Court, I'm sure, is aware, we are traveling under Rule 9.130A3C9, and this is for non-final orders that determine, as a matter of law, a settlement agreement is unenforceable, is set aside, or never existed. It's our contention that the trial court's order herein that denied our motion to enforce settlement essentially determined as a matter of law that a settlement never existed, based on the trial court's conclusion that the parties did not reach a mutual assent on the material essential terms of any purported settlement.
Why isn't that a finding of fact?
Your Honor, it's typically a question of whether a contract has been formed is viewed as a question of law, and it's reviewed de novo by the courts. It's our contention here that the order in question determined as a matter of law that there had been no mutual assent based on the facts that were presented into evidence. There really is not too many essential facts in dispute. I would argue that there are no facts in dispute.
Hold on 1 second, though. The settlement agreement never existed, which is part of the rule you were traveling under. It seems like your interpretation would mean that any time that a trial court may have found that there was a settlement agreement that never existed, that would be as a matter of law and appealable. What makes this different than anything else?
I don't think that it would be in every single case. I think that there's certainly the situation where a trial court may conclude that there is some factual issue in contention. I believe that here the essential facts that we needed to establish that there had been a binding settlement entered into by the parties were not in dispute, and so it's our contention that the trial court essentially applied the law to these facts and determined as a matter of law that that there had been no settlement, essentially, that there had been no mutual assent.
The law under sovereign immunity before they amended the rule was very similar. And under that previous law, under the sovereign immunity cases, it said that the order itself must state that the trial court was making a determination as a matter of law. Why shouldn't we apply that law to this section of the rule in the same manner that the sovereign immunity question was applied?
So we believe that the Supreme Court's recent decision in Florida Highway Patrol versus Jackson, it essentially held that based on the court's prior precedent, which it collectively referred to as the Hastings-Reeves precedent, it did find that the trial court's order had to determine as a matter of law, but I don't think that, or I would respectfully disagree, that the order itself has to expressly say as a matter of law. In fact, the Reeves decision had an order that stated as a matter of law that that the court was denying the motion, and even in that instance where those exact words were used, the court found that in effect it wasn't as a matter of law. And so I think the way that we are reading Jackson is to indicate that yes, the order needs to expressly set out, for example, in the case of Jackson, that sovereign immunity is being conclusively denied as a matter of law. In other words, that the party claiming sovereign immunity is not entitled to this immunity. But I don't necessarily think that the order itself has to state any particular magic word, such as a matter of law, or anything to that effect. I think that the intention by the courts in this situation is more so to be able to draw from the order itself, without looking at the record on appeal, that the determination was in fact one as a matter of law. I think that is intended, and I think past case law has shown that it's more so for situations in which you have an order where it's a simple or an unelaborated denial of some type of immunity, workers' comp, sovereign immunity, or in this case, if the order had simply said denied without any sort of explanation of the trial court's rationale. But I do think that this particular order does contain the trial court's basis for its legal determination. It cites the case law that it relied upon, and it expressly sets out that it is denying our motion based upon the court's conclusion that there was no mutual assent to the essential terms of the settlement agreement. So again, as I stated, I don't believe there needs to be any sort of particular special language or any magic words such as a matter of law. I think that generally speaking, the determination of whether a contract, or in this case a settlement agreement, has been entered into is a question of law that is typically reviewed by the courts de novo. And so again, we would set out that this order does make a determination as a matter of law that there was no settlement agreement, and we believe this is sufficient to come under Rule 9.130 for review by this court. If the court has no other questions in terms of the jurisdictional issue, I will move on to the merits of our argument.
If I can interrupt one question. Judge Sow's order came out before the Supreme Court's decision. So do you see any timing issue there in terms of is the decision retroactively applied because it's procedural versus substantive?
I don't think so, and the reason that I would say that there should not be an issue there is that effectively what the Jackson decision did is really set out, yes, it did make a change going forward in terms of the sovereign immunity provisions, and it actually amended the rule, but I believe that its rationale and its holding for why it ultimately concluded that there was no jurisdiction under the rule as previously stated really was based on prior precedent that was already in existence, and which I think that this current order does comply with. So I don't think that it necessarily, outside of the fact that it did change the rule as it pertains to the immunity provisions, sovereign immunity, qualified immunity, I don't think that it, in essence, set out any new law as it relates to the jurisdictional aspect of the rule, the language determining as a matter of law, you know, whatever the particular provision may be. So I don't think that there should be necessarily an issue of timing, given that our present order was entered before the Supreme Court issued its Jackson decision.
Before Jackson was issued in January of this year, from this court, before the entry of Judge Sow's order, you had the Jackson decision from this court, which had already been out, and the McLean decision, which had essentially ruled on the similar issue. So even without the Supreme Court's decision, prior to Judge Sow's order, there were decisions in this court recognizing that under the prior Hastings-Reeves precedent from the Florida Supreme Court, there has to be an express statement on the face of the order. What's your response to that?
Thank you, Judge Nordby. Yes, I would agree with that. And again, I think that the statement that's contained in our order does satisfy that requirement. In terms of the merits of our argument on appeal, it's our contention that the trial court erred in denying the motion to enforce settlement here because there was an enforceable settlement agreement entered into, and there was an agreement on all material essential terms. The record reflects that this case arises from a motor vehicle accident that occurred on August 4th of 2014. Shortly after the accident, GEICO, which is the insurer for Mr. and Mrs. Powell, received a letter of representation from a Mr. Willie Walker on behalf of Mrs. Woodard, which indicated that Mr. Walker was representing Ms. Woodard, and the following day, the GEICO adjuster, Mr. Barry Semley, he reached out to Mr. Walker, and it was Mr. Semley's testimony that Mr. Walker offered to settle Mrs. Woodard's claim for the policy limits of the Powell's insurance coverage, and that Mr. Walker instructed GEICO to make the check payable only to Mrs. Woodard, to provide an affidavit of coverage, and to provide a proposed release. All of which
Prior
were-
to the check being cashed, wasn't Geico on notice that another attorney was asserting that he represented this woman?
Yes, Your Honor. However, at the point in which Geico became aware that there was a second attorney that was representing Mrs. Woodard, it's our contention that the settlement had already been entered into. So the settlement was entered into approximately, so the call with Mr. Walker and the Geico adjuster occurred on August 7th. On August 8th, Geico tendered the policy limits, and on August 11th, they provided the affidavit of coverage and the proposed release to Mr. Walker. So it's our contention that at that point, a settlement agreement had been entered into. We didn't, or Geico was not put on notice of Mr. Duffy's representation until approximately August 27th, and I believe the evidence in the record reflects that Mr. Duffy was not actually retained until August 19th.
So you're not relying on the check cashing as an acceptance of the offer?
So we are not relying on the check cashing as acceptance of the offer, but we are relying on the check cashing as a ratification of the settlement agreement that was previously entered into. Our contention essentially is that the settlement had already been entered into, had taken effect at the point in which we complied with the terms of Mr. Walker's original demand, which was done at its earliest August 8th or August 11th. At that point, it's our contention that there was a settlement agreement in place that was basically an acceptance by Geico of the express terms. In other words, we mirrored the terms of the offer made by Mr. Walker on Ms. Woodard's behalf.
If I could ask, there's no document reflecting the settlement, is there?
So the only, what's in the record.
I'm sorry, an executed and completed document. In other words, each party signs the release. I mean, usually you have a lot of paperwork when you have a settlement. People sign off on it and the check gets issued. But here, all I see is a check and no documentation that's been executed.
Correct. So the only documentation in the record, as Your Honor noted, is the check as well as the letter that was sent by Geico's adjuster to Mr. Walker containing the affidavit of coverage and the proposed release, which is dated August 11th and is at the record at page 187 of our appendix. Outside of that, you are correct. There is no other written documentation reflecting the settlement. There has not been a signed release by Ms. Woodard. However, the release was provided, it was contemplated, and we believe that having cashed the check, Ms. Woodard has now ratified that agreement, and so we are entitled to obtain a signed release and to have this action dismissed at this time.
Okay, you're down to 2 minutes.
So if I can, I would like to reserve the rest of my time for rebuttal. If I could just briefly address the issue of the essential terms. As I said, I believe we've complied with all of the essential terms that were set out in the offer by Mr. Walker, and so it doesn't appear that there is any dispute as to those essential terms. If I can, I'll just reserve the rest of my time for rebuttal.
Okay, thank you. The applicant may proceed whenever you're ready.
Yes, Your Honors. Thomas Duffy on behalf of Mildreda Woodard, dealing with the jurisdictional issue. A couple things as to that. We would, in their motion that they filed back on October 5th in response to an order to show cause, they concede and are making arguments that this meets the standard of an appealable final order. But they also asked that the court consider, if it doesn't fit that way, to consider treating this case as the court did in Coutreau versus Operator Service Company, where they basically jumped and approached it as if it was a denial or granting of summary judgment on that issue. The framework that this comes to you, and I think some of the conflict between the appellate rules and the underlying rules, is that oftentimes this is presented a motion to enforce settlement, and it is an affirmative defense that could be later raised, but if it is so clear cut, it gets handled in the preliminary stages and saves everybody a lot of effort. The thing for the courts to determine, and I think Judge Soud was clear, although maybe not so much in his order, that this was the last we were going to hear of this issue. When he reviewed and described the pre-suit history as unique, extraordinary, and tortured, I think if you read his assessment of the actions of Geico, it delves into Geico's own actions, setting up a situation where they've made a bed and they've been forced to lie in it. While he doesn't use the words "as a matter of law" in the order, I think that that I am fine with the court going ahead and ruling it. Appellant and
The case law that's out there, though, says we can't look at the record per se. The only thing we can do to determine appealability is look at the order itself.
And now, I would concede that the order doesn't clearly state that Judge Soud was ruling that they could not bring this up as a jury issue as an affirmative defense. And I think that is the key that distinguishes where the appellate courts don't want to be ruling on something that really was still an issue that was going to the jury. In this case, it would be faced with my summary judgment on the issue in the litigation. One thing that I am aware of is that from having dealt with this case since a long time ago, is that all the facts are in on this issue. I think if it got remanded and Judge Soud, although it's not Judge Soud anymore, he is not in this division, would move forward with the case, but get to my summary judgment issue pretty darn quick. Probably give the defense an opportunity to do additional discovery and open it for more evidence if they feel needed. But I don't know if it's affirmatively stated in this, but in speaking with counsel, we feel that all the issues are in.
Mr. Duffy, if I could ask you a quick question.
Sure.
On the record that we have, in your view, if the trial judge felt as if, as a matter of law, the motion should be denied, that there is no settlement agreement, what more would he have had to do in his order to make it comply with Jackson? In other words, obviously, if he said as a matter of law, I find that's helpful. I mean, that's those magic words. But at the same time, is he supposed to say the facts clearly demonstrate, or is he supposed to show there's no dispute whatsoever? In other words, how would this order have been written to make it appealable under Jackson?
I scribbled that out somewhere. Here it is.
Because there may be in some cases where the facts are so undisputed and so crystal clear that as a matter of law, there's not a settlement.
Yeah, if we could have conferenced with him afterwards, or we had a motion for reconsideration, but because since the appeal was filed, he felt constrained that he couldn't touch the issue. It would have been, Judge, or just a simple question, Judge, are you leaving this open for additional, discovery and a subsequent ruling? If not, if it's so clear cut, if the defense agrees that all the facts are in on this issue, and these will be the same facts presented down the line, then Judge Orley, will you grant my motion in limine as Mildreda's lawyer to strike the affirmative defense based upon your ruling as a matter of law? So probably a subparagraph after as a matter of law that, this is the law of the case and would pertain to that there any affirmative defense alleging settlement and compromise will be stricken based upon my evidentiary hearing and ruling after hearing all the evidence presented by both sides.
If we find there's no jurisdiction and it goes back down, where are you then? You said it's going to be you're going to rely on a motion for summary judgment on the issue, or you're going to let it go to the jury if it doesn't get granted. Is that how it would play out?
I guess we would go back down, and the judges ordered them to file an answer, and an answer would be forthcoming. And I would probably call counsel and say, do you need some more discovery on that issue? Because it's one that's so separate and distinct. And if you read the brief opinion in that Cotru case that I cited, it's so separate and distinct from the other issues in the case involving a car crossing the center line and my client having 3 major surgeries and a $250,000 lien. It is just, was there a meeting of the minds on these facts? And that can, I think, clearly and quickly be determined by a new judge in a new division. For this judge to go and try and define or figure out what Judge Soud's intent was on the affirmative defense, I don't know if that gets us anywhere.
But isn't it fair to say that Judge Soud resolved factual disputes and reaching his order? In other words, the parties didn't stipulate to a set of facts for purposes of the motion to enforce settlement. You all had some disputed facts, and he had to decide based upon his determination what the facts are, whether the settlement agreement should be enforced or not, correct?
Correct.
Thank you.
As far as the merits of the issue, on whether there was a settlement agreement reached, number one, I'd ask you to think about what is the most closely analogous case that the defense has cited to establish that what happened here created some type of contract. There ain't an appellate case close to this, because this didn't come close to being a settlement agreement. There are 2 really important facts as you keep looking over the facts. One is that in the way in which phone calls are handled initially on finding out coverages so you can quickly and adequately make decisions for your client, things are done and conversations are made. What's key is the actual conversation between Walker and Stemley. They, in their brief, say about 4 different times what was said in that without ever quoting specifically what is the evidence. And the evidence of what was said in that statement, and I have it on page 6 of my statement of case and facts at the bottom of my brief, is that Stemley told Walker that the bodily injury coverage for the accident was $25,000. That is not information that he had told Mildreda Woodard over the phone the day earlier when she was recuperating from surgery and reached her on the phone. Mr. Walker responded by stating that he would more than likely, just tender the check to the claimant. And Walker told Geico to make the check payable to her, and mail us an affidavit and get us a release.
Can I interrupt and ask a factual clarification? The accident occurred on August 4th, 2014, and the purported settlement was entered pursuant to Mr. Stemley going out and contacting the woman injured in the hospital. It was completed on August 8th. So it was from the time of the accident to the time of the settlement was 4 days. Is that your understanding?
That's what
the alleged settlement. I'm sorry.
That's what they contend, but I contend that how could Mildreda have settled her case on the 8th if she didn't know how much the coverage was? How could she? And Stemley knew this. Stemley knows that Walker had to do a lot of things before he could take this small amount of money, $25,000, and start dealing with a big, huge Shands lien, and also determine if she's entitled to some coverage. So there were things that had to be done.
What Stemler, the material that Stemler sent out with the check, would that have been sufficient to be a offer, at least, of a settlement? That could have been accepted?
No, that could have been considered an offer. What another key point is, and know this.
Okay, that's my question. Okay, could that have been considered an offer?
Yes, that could have been considered an offer.
That could have been accepted.
That could have been accepted. But no release was received by the Walker Law Office until the day after she signed the check. Mrs. Woodard and that release were never in the same room at the same time. and she wasn't told anything by the Walker Law Office about any of the essential terms of any alleged settlement agreement that he engaged in with Geico. Based upon my representation of her and them not confirming with Walker that he was fired, Walker was basically acting as an agent for Geico at that moment. I was her attorney. I had sent them 3 letters. Get the check back from him, put stop payment on the check. I got to see if she's entitled to UM. I did the same thing.
If I could ask, Walker never got any compensation out of this, did he, or that we know of?
No. No. She was called on 4 in the afternoon, coincidentally on, I think the 5th day of my 5-day letter, and said, come pick up the check. And she is destitute. There are findings that only Judge Soud could make because he saw her walk into the room and testified he felt her to be credible, but so unsophisticated in these facts that for her to be handed a check, be told it's all yours, this is from the accident, that somehow she agreed and knew that there would not be any more money forthcoming if she had additional surgery.
You know what strikes me? You're arguing a lot of facts here. It seems to be, arguably that this was not as a matter of law. I mean, that she was the unsophisticated. I'm going back to the jurisdictional issue a little bit.
Okay. Yeah, well, I was more in tune with the merits of the issue. If there's a point I need to go back and address on the jurisdictional issue, I will.
You just said all the facts were resolved, and it seems like you're making a factual argument here.
Well, Judge, I just think there are so clear cut that this doesn't come close to creating a contract based upon everything that Judge Soud heard and ruled on.
Is it, if I could ask you, what troubles me is this the way it works? An accident happens, people go to the hospital in 4 days. There's paperwork and a check trying to get settlements from folks who are still in the hospital or barely out of the hospital. Maybe a good thing, gets money in their hands. At the same time, it's a little disconcerting.
Yeah, I'm not thrilled with runners for Geico walking around with shands, knocking on doors with checks and pens and papers to people who are on opioid pain medicine after having just come out of surgery. I think we could handle claims in the first few days after a major accident a little differently than that. And that's what it was here. How I got to Mr. Woodard is the driver of her car called me, and the paperwork from that runner was sitting next to his desk, which he had not signed, and called me, and he hired me. We ended up finding $100,000 of available UM coverage that he would have lost if that runner would have had him in that hospital, in that setting, sent that release and signed that check. In this case, Ms. Woodard never saw a release. She was given a check by them, and the case should proceed. Are there any other questions? I think I'm done.
Okay, thank you.
Thank you, Judge.
Appellant rebuttal.
Can't hear.
I can't hear you.
Sorry. Sorry, I didn't unmute myself. I apologize. Just a few points that I'd like to address very quickly. To Mr. Duffy's point, and I would agree, if this court concludes that there is no jurisdiction, I think it would necessarily have to conclude that there hasn't been a determination as a matter of law, meaning we can raise the settlement as an affirmative defense in our answer and try to continue to pursue this argument via summary judgment, as Mr. Duffy noted, or as an affirmative defense or before a jury. Absent that conclusion, I think that there needs to be a determination that it was as a matter of law and would need to be addressed at this juncture. To the merits, to Judge Makar's question, yes, this transpired rather quickly. The policy limits here are not very high, and while yes, initially we did reach out, or Geico did reach out to Mrs. Woodard when she was in the hospital. Ultimately, the settlement discussions and the offer were engaged in with her attorney, for whom we had a letter of representation. We were told she was being represented by Mr. Walker. We spoke to Mr. Walker. We were made an offer and we accepted. If this court were to disagree with that, I think that you could also consider, as was discussed, that the sending of the check and the release was itself an offer by Geico, in which case Ms. Woodard accepted that offer when she cashed that check. Again, our initial contention and our primary contention is, I see I'm running out of time, that the settlement was entered into when we met the terms of Mr. Walker's offer. But after
Okay, your time is run. Thank you very much.
Thank you, Your Honor, and we would just ask the court to reverse.